All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience du Cour pénal international est ouverte. Please be seated. Veuillez vous asseoir.
L'audience est ouverte.
Presiding Judge, the hearing is open. Good morning, all. Court officer, would you like to call the case, please?
Good morning, Mr. President, Your Honors. This is the situation in the Republic of Mali in the case of the prosecutor versus Al-Hassan Al-Abdul Aziz Al-Mohammed Al-Mahmoud. Case reference ICC 01-12-01-18, and for the record, we are in open session.
Presiding Judge, thank you very much, Court Officer. I welcome all who are present here in the courtroom. And of course, I welcome Mr. Al-Hassan, who is also present. I also welcome those who are in the public gallery and all those who are following these proceedings remotely. As each morning, I would like to hear from each of the parties and participants who is present today. Mr. Dutertre, would you like to introduce yourself and your team? Mr. Dutertre. Good morning, Your Honours. Today, the Office of the Prosecutor is represented by Moussa Alafi behind me, Sandra Schroeters, Marianne Sardachi, Caroline Leroy, Mr. Garcia, Yamaguchi, and myself, Gilles Dutertre, as well as Yanogo Pengdwende. And I would like to also welcome all those in and around the courtroom, as well as the public. Presiding Judge, thank you, Prosecutor. I turn now to the defense. Ms. Taylor, would you like to introduce yourself and your team? Thank you.
Thank you very much, Mr. President, Your Honours. The defence for Mr. Al-Hassan is represented today by Dr. Felicity Gary, to my right, and Maître Melissa Boyolucia, to my left. And going around this way, we have Maître Alka Pradan, we have Maître Leila Abid, we have Maître Mohamed Youssef, we have Professor Mohamed Badar, we have Mr. Maulud Al-Ansari, we have Maître Kelsey Ryan, and we have Ms. Brianna Dyer. Thank you and myself, Melinda Taylor. Thank you very much. And good morning to everyone in and around the courtroom.
Presiding Judge, thank you very much, Ms. Taylor. I now turn to the legal representatives of victims. Mr. Nsita, would you like to introduce yourself and your team? Mr. Nsita. Good morning, Your Honours. The victims are represented at today's hearing by Ms. Priske Bieke Dipanga, Andres Felipe Arias Morales, by Ms. Julie Goffin, my colleague Mayumbo Kasongo, and also by Seydou Doumbia, who is attending in Bamako. I too am present, obviously, but I wanted to point out that to the chamber that due to very heavy rain in Bamako, the two other members of our team are currently still underway and doing their best to join us in due course. So they shall be joining us with a slight delay this morning. Thank you.
Merci beaucoup.
Presiding Judge, thank you, Mr. Nsita. And thank you very much for that little clarification regarding your two colleagues who are in Mali. Now, today is our third day. The third day during which we are hearing the closing statements of the parties and the participants. This morning we are going to hear submissions from the defence. We began to hear their closing statements yesterday. We shall now hear the remainder thereof. I would now like to hand the floor over to Ms. Taylor.
Bon matin, Monsieur le Président, Mesdames les juges, avec votre permission, je vais m'adresser. Ce sera moi qui s'adresse.
In fact, Your Honour, it is I who shall address the court if I might. So I will be addressing the allegations of forced marriage and other inhumane acts, such as sexual slavery, rape and rape in detention. I will be covering the following 4 topics. First of all, the absence of proof beyond a reasonable doubt that there were forced marriages as part of a common plan. Secondly, the lack of evidence beyond any reasonable doubt that Mr. Al-Hassan knew that there were alleged forced marriages, and also the absence of proof that he contributed to the alleged forced marriages in any way. Secondly, the fact that the environment was not coercive and that Ansar Dine did not take advantage of such an environment. And finally, the fact that there is not evidence beyond any reasonable doubt which would allow one to find that there were rapes in detention as part of a common plan and that Mr. Al-Hassan was aware of them and contributed to them. First of all, the defence puts it to you that the prosecutor has not proven to you that the group had a common plan to force, including to force women to marry. The prosecutor alleges that Iyad al-Khali said that he would give wives to men who joined the group. Now, this allegation is from an individual who was captured at Agel Hok at the beginning of 2012. Now, that individual allegedly heard this from a deserter who had joined Ansar Dine. That deserter allegedly said that Iyad al-Ghali was giving women to members of the group. Now, this is hearsay, which is not corroborated. What is more, it relates to a point in time which is outside the charging period and is not within the geographical scope either. And it is totally unrelated to what was happening in Timbuktu. Given the circumstances surrounding that event and the position held by the witness, what he has to say cannot be given credibility and is not reliable. Now, contrary to what the prosecutor claims, witnesses have explained that the members of the group were educated in the Maliki approach to marriage, which requires that consent be obtained from the bride or the guardian, depending on the case. The members had to respect local traditions. This was explained by the prosecutor's witness, P155, as well as defense witness D202, the prosecution witness at transcript 103, page 11, and the defense witness at transcript 203, lines, page 18. D529 also testified to the effect that the group had not applied pressure or encouraged its members to marry. So there was never any question of women being taken as a wife without their consent. Mole, when this testimony furthermore, giving testimony under oath, this witness did not refer to the document. He didn't refer to any particular evidence of forced marriages in Timbuktu between members of the group and local women, but rather said that forced marriages had always existed, as had various other types of discrimination against women in various forms, such as forced marriage, polygamy, and indeed circumcision. In any case, the reliability of that article is also undermined by the fact that the witness was unable to differentiate between the different groups. In other words, between Mujau and Ansar ad-Din, in the case in hand. The prosecutor also refers to a UN report which was published in November 2012, which contains general allegations regarding groups who were involved in forced marriages in Timbuktu. Now, this report cannot be used to attribute an intention to members of Ansar ad-Din. Once again, there is no evidence that Mr. Al-Hassan had read that report. Now, throughout the course of this trial, Your Honours, we have heard evidence to the effect that various married women during the events could remain at home with their families and also receive visits from female friends. And here the defence would refer to its final brief at paragraph 56. Furthermore, women could refuse to marry and there were no consequences, as set out in paragraph 54 of the defence's final brief. The simple fact that members of the group married local women is not sufficient to find that forced marriage was committed in furtherance of a common plan. As regards the proof regarding the particular incidents in the charging document, the defence would refer you to its final brief in paragraphs 216 and 259. We would put it to you that the prosecutor has not proven to you that these offences took place or that they were part of a common plan. The prosecutor is asking you to make inferences from circumstantial evidence, and that is not reasonable. Now, secondly, Mr. Al-Hassan, I would like to address Mr. Al-Hassan's alleged specific conduct and contribution to the alleged common plan. First of all, no evidence has been provided that Mr. Al-Hassan had knowledge that police patrols contributed to forced marriages and was used to identify women and to arrange marriages. Now, the prosecutor gives the example of P520, 5380, and P610. Even if we were to take it that the events took place as recounted by the victims, it is significant that none of them made a link between the patrols and their marriages, and none of them identified Mr. Al-Hassan. So it would not be a reasonable inference to make from the evidence provided by the prosecutor, but would simply be speculation. Now, the prosecutor also holds it against Mr. Al-Hassan that he did not take measures to limit the behaviour or the conduct of Ansar ad-Din members when on patrol. Once again, to do that, Mr. Al-Hassan would first have had to have knowledge of such a practice. What Mr. Al-Hassan did know was that the members of Ansar ad-Din had been informed of the ban on rape, and he also knew that members of Ansar ad-Din it had been explained to them the nature of the local practices and traditions, as stated in paragraph 55 of the defence's final brief. Now, as stated in the pretrial Chamber's decision confirming the charges at paragraph 948, the statute requires that the contribution referred to in Article 25(3)d must be important, must be substantial, that is to say, and must meet a certain threshold. The fact that Mr. Al-Hassan was a member of the Islamic police is insufficient to prove such a contribution. The prosecutor does not specify in his final brief that Mr. Hassan behaved in such a way that the patrols were used to organize arranged marriages. The prosecutor has also not provided evidence that Mr. Al-Hassan was responsible for training and discipline within the police, or that he neglected his duty in any way. Now, as regards the payment of dowries, the defence puts it to you that the only conclusion that could be drawn is that Mr. Al-Hassan did not contribute in any way to a common plan by providing assistance to the members of his group in the form of a dowry to marry a local woman. Now, according to the prosecutor's final brief, Mr. Al-Hassan wrote a request for someone called Mohammed to obtain financial assistance to pay a dowry. Now, this is based purely on a statement given by Mr. Al-Hassan, which, as was explained to you yesterday, was given while he was under the effects of torture. That statement was given on the 6th of October 2017, the self-same day that Mr. Al-Hassan asked the investigators of the Office of the Prosecutor to intercede so that he could be transferred to a regular prison to escape from the torture that he has been subjected to at the GGSE. So, on the basis of what was said by the accused under the effects of torture, can this conclusion be drawn that he was contributing to forced marriages? Also, please remember that Mohammed is one of the most commonplace names in Timbuktu, and this is an insufficient basis to know whether there had been consent or not, whether the members of the family were approached regarding the proposed marriage.
Est-ce que le simple fait d'avoir rédigé une demande pour un membre du groupe,
there was a request of the group to assist to pay the dowry, and that this constituted a major contribution of a nature to provide influence. And when the evidence could be there that Mr. Al-Hassan did this, can it be concluded that there was a causal link? The defence says no, but once again, the prosecutor asks you to speculate because the evidence does not support the references you are asked to make in the light of the proceeding. The only logical reference which can be made is the fact that Mr. Al-Hassan possibly contributed to helping the conclusion of marriage according to local customs. Furthermore, there is no evidence to the extent that Mr. Al-Hassan exercised any pressure on women such that they marry through his administrative functions in the police. P150 furthermore admitted not having any recollection that Mr. Al-Hassan acted as an intermediary in marriage. Even if P66 stated that it was normal, even before 2012, to use prominent intermediaries in Timbuktu, as was his case, in order to arrange marriages. Furthermore, the simple fact that Mr. Al-Hassan knew that members of the senior police officers had married local women, namely Adama and Abu Dar, doesn't confirm the fact that Mr. Al-Hassan knew the intention of the group to put pressure on women, or that they were not able to refuse this marriage. The defence even presented evidence to the fact that Adama's marriage was consenting, and I refer you to paragraph 20 of the response of the final prosecution brief. Now, where it concerns the allegation to the effect that Mr. Al-Hassan mediated in order to resolve marital disputes, the defence puts it to you that the prosecutor has in no way proven that he played any such role in relation to the incidents charged, or that he knew that he assisted in the mediation of marriage which resulted from a non-consenting marriage. And once again, P66 will confirm that also playing a role as a mediator in the framework of marital conflicts before and during 2012, and that it was a normal practice. How could Mr. Al-Hassan have known that he contributed to a crime if he was a mediator at the time? It's also important that women complained for different reasons for having suffered harm in their marriages, and they were accorded a divorce by the Islamic Tribunal. They had the option to divorce, and I refer you to the footnote in the defence brief where we list several judgments in this point. The fact of playing a mediating role within the framework of marital disputes is completely irrelevant. Thirdly, the members of Ansar Deen did not in a coercive environment for sexual crimes. Contrary to what the prosecutor alleges, bearing arms by members of the group was legitimate defence only, and the members were well educated to this effect, as set out in the defence brief, namely paragraph 49 thereof. In addition, the prosecution witness P654, a prominent person from Timbuktu, confirmed that with the occupation, men started to give women credit and respect. They were no longer provoked in the streets, and the imposition of Sharia ended theft and rapes. And this was a positive aspect of the occupation. And here I refer you to the transcript T133, page 35 thereof. This statement of the witness is revealing. How could the prosecutor confirm that there was a coercive environment if the women of Timbuktu were more respected, that there was less pressure on them, and that they could obtain divorces? Finally, where it concerns the commission of rapes on certain women in detention, the defence puts it to you that the prosecutor wasn't able to demonstrate that these rapes were part of a common plan. No evidence has also been presented to demonstrate that Mr. Hassan was present when the women were in detention. Nevertheless, it was demonstrated by the defence in paragraph 134 of its final brief that most of the women who were detained by Mohammed Musa while he was in BMS. And not to denounce the fact that there had been rapes in Timbuktu. And here I refer to Ms. Taylor's submissions from yesterday. The prosecutor asked the chamber to draw the conclusion that rapes were committed in detention and that Mr. Al-Hassan had sufficient knowledge, whereas the proof is the fact that the people who were present at the time themselves were not even aware of this. The simple fact that Mr. Al-Hassan confirmed that the Convention of the Proper Behaviour and the Prohibition of the Blameworthy did not establish that there was a conduct which adopted which produced a causal effect between the commission of rapes in detention. The simple fact that women were detained does not mean that they were victims of sexual violence. The prosecutor hasn't presented reliable and credible proof to the extent that guards were known as being abusive and acted in impunity, and it would be realistic to believe that they could guard women without being subject to abuse. The reference of the prosecutor to the judgment of the ICTY in the Shoshka effect, namely 327 there, paragraph 327 thereof, is erroneous. They knew that the fact that they were only guarded by men doesn't mean anything. Such a presumption, legal presumption, does not exist. On the contrary, it is a fact that the prosecutor must prove, which is something that the prosecution has not done. The prosecution put it to you before yesterday that Ansardine clearly exposed all women and young girls who were detained to the risk of rape intervening within the normal course of events. A risk is not a sufficient threshold to meet the criteria accepted by this court. Ms. Taylor has already addressed the test which requires almost certainty. A risk is not almost certainty. There is therefore no proof beyond reasonable doubt to support the fact that Mr. Al-Hassan would have contributed to the so-called commission of rape or adopted a behaviour which have facilitated the commission of rape, or even that he knew the intention of the group to commit these rapes. Thank you.
Je vais passer la parole à mon collègue.
I give the floor to my colleague.
Merci beaucoup.
Thank you very much, Council, for your brilliant presentation and above all for your brevity. And the floor is now to your colleague, Maître Youssef.
Thank you, Mr. President.
Allez-y, Maître Youssef.
Thank you.
Let's go ahead.
Mr. President, Your Honours, this part of our closing submissions concerns the Islamic police reports and the prosecution's claims regarding their link to the Islamic Tribunal judgments. It is our submission that Mr. Al-Hassan did not make a culpable contribution to the proceedings before the Islamic Tribunal. Our submissions in this section have 5 small parts: the status of the evidence on the specific issue, the methodology of the police reports, the limits of the police's competence, the Islamic Tribunal's methodology, and last I will discuss the voluntary nature of the population's interactions with the Islamic police. Overall, it is our submission that the reports of themselves demonstrate that Mr. Al-Hassan was a low-level clerk. His actions were pursuant to the Islamic Tribunal decisions, which, when properly put in context, were orders. Thus, he cannot be said to have individually committed crimes or made a culpable contribution to a criminal purpose, as alleged, or at all. The prosecution provided us with Islamic Tribunal judgments and Islamic police reports and claimed the judgments were based on the police reports. And for most of the charged incidents, there is no evidence from the parties mentioned in the Islamic Tribunal judgments or the police reports. Witnesses were called who may have had knowledge about those incidents, but their personal knowledge of the incidents was not established. They never witnessed the drafting process of the police report. They were not present in Timbuktu throughout the entire period, so they could not have possibly known about every specific incident. It was therefore crucial to establish their personal knowledge. And instead of calling that evidence, Your Honours, the prosecution is asking the chamber to speculate. When those witnesses appeared before this chamber, all they were asked by the prosecution was to repeat the names and dates they could read on both the reports and the judgments, repeating names and dates on two separate documents gives no weight to the documents. Anyone who could read Arabic could have done that. The prosecution in the closing arguments, for example, referred to an alleged tribunal judgment. This is item 98 and 99 on the prosecution's list. A handwritten text inside a notebook. Here's another good example where a prosecution witness could have had knowledge about this incident, or the author, or the circumstances surrounding the drafting of that note, or the link with Mr. Al-Hassan, if any. And that witness testified before the chamber and was shown the document in the middle of a batch of documents, but no questions were asked about this incident whatsoever. So once again, the chamber is asked to speculate. And the Islamic Tribunal didn't hide it when they relied on other investigations for its findings. Let's take the example of incident 42. Here is an incident where Mr. Al-Hassan had no role whatsoever. The locals complained about the persons in question, as confirmed by witnesses D514 and witness P984. They were arrested by the security battalion and then taken to Hezbollah. A prosecution witness confirmed that a member of Hezbollah always oversaw the application of a sentence, and confirmed that in this particular case, a member of Hezbollah is seen reading out the sentence prior to execution. Mr. Al-Hassan was not present during the execution of the sentence, and the tribunal even recognized in the judgment the role of Hezbollah and the emir of Hezbollah in conducting investigations on this case. Hezbollah, Your Honors, not the police. We also have examples where the Islamic Tribunal judgment contains information not in the police report, which again shows that the tribunal did not rely on the police reports, whomsoever instructed to draft them or drafted them. For example, incident 19. We have a report that is one line, a driver found with 2 jars, one containing water and one containing cotton, as well as a piece of paper containing a magic text. This is it. This is item 98 on our list, Your Honors. The tribunal judgment, on the other hand, contains information on the route the person in question does as a driver, a more specific description of the items found in his possession, where the items were found, and the mention of his grandfather's funeral. It's item 99. Similarly, in incident 20, the report is only 3 very brief lines. The judgment, on the contrary, refers to the specific items in the possession of the person in question. It refers to the individual being questioned by the Islamic Tribunal and confessing before them. And while the prosecution claimed that Mr. Al-Hassan wrote the police reports, they did not establish how he received that information, especially that Mr. Al-Hassan was not acting alone in the police, and he had superiors who gave him orders. These alleged incidents demonstrate that the tribunal considered every aspect of a case when seized of a matter. Their work was not complementary to the police. Their work was done from scratch, under oath, independently, without reliance on the police report, as if the police reports never existed. Furthermore, the judgments make no mention of a police report. The mere existence of a police report doesn't mean the judges even saw it. And any link we try to establish here would be an assumption. And in some cases, before the Islamic Tribunal, the chamber has heard there's no police report at all. And the only logical conclusion here is that the Islamic Tribunal was able to, and did indeed, conduct the proceedings without any role by the police whatsoever. And those examples can be found in items 100 to 112 on the defense's list. It is therefore crucial not to generalize or make assumptions or speculate on the role, if any, played by the police or Mr. Al-Hassan. This is the only safe approach to this case. on the issues when considering contribution. Mr. Al-Hassan made no contribution at all. As foreshadowed, I go on to make submissions on the methodology of the reports. The police reports are nothing but a summary of information, an untested account of what may have been said, and it was left to the Islamic Tribunal to verify or completely disregard. Almost all of the reports are half a page, and some of them are one line, which suggests that the police conducted no investigations. They conducted no investigations themselves. And this does not establish beyond reasonable doubt the role played by Mr. Al-Hassan, if any, in the proceedings before the Islamic Tribunal. Mr. Al-Hassan could not and was not qualified to predict how the tribunal would issue its findings. A prosecution witness testified that the Islamic Tribunal followed an approach of, and I quote, avoiding punishment should there be any uncertainty, and mitigating punishment commensurately with the nature of the crime in question. This was within the competence of the Islamic Tribunal, not the police. And we can also draw inferences from the fact that Hezba's composition included judges in the Islamic Tribunal, whereas the police did not. So the existence of the police reports further demonstrates the police's lack of competence or authority. Otherwise, the referrals would not have existed and the police would have issued rulings itself. And this leads me to the third part of this section concerning the limited competence of the Islamic police. There was no discretion or leeway for Mr. Al-Hassan or any member of the police vis-à-vis the processing of complaints or the implementation of the tribunal's verdicts. When the report reads to the Islamic court, this was not a prosecutorial act of seizing a court. It was nothing more than an indication of lack of competence, an indication of the definitive end of the police's minimal role in the case. The police, Mr. Al-Hassan and his superiors, were all under the obligation to transmit complaints to the tribunal. It was similar to the role of the registry in transferring the parties' submissions to a chamber. And even with that analogy, the police were not always approached, and parties went directly to the tribunal or through Hezba. The police was also under the obligation to transport individuals to the Islamic Tribunal, just like Mr. Al-Hassan was transported to the courtroom today. A transport service is not a contribution to the legal proceedings before a tribunal. Qutaiba, a key scholar in 2012, confirmed that the police or Hezba would be committing a forbidden act if they interfered with complaints for adultery, theft, or drinking alcohol. It was a forbidden act because the Qadi was the religious authority entrusted with the interpretation of the law and the issuing of sentences. Not the police, and certainly not Mr. Al-Hassan. We have heard witness D202 testify that questioning Sharia is questioning God or his representatives on earth. And as prosecution witness P65 testified, Mr. Al-Hassan was powerless to depart from the system. He was under the obligation to seek the decision of his emir and could not bypass him. And this puts superior orders into context, upon which Dr. Gary will speak later. We have also heard a prosecution witness testify that the Maliki legal school, also called in Arabic Al-Madhhab Al-Maliki, to which the locals were most accustomed, was followed by Ansar ad-Din and the Islamic Tribunal. It is an eminent and well-established authority in Islamic governance that is not inconsistent with international law. This legal school is not only followed in Timbuktu, but almost all of North and West African states, and can be found in countries in the Arabian Peninsula. This system of governance does not permit the police to make interpretations of the law or decide on disputes between parties or issue sentences. And even in a system of Islamic governance, the police still functioned like a regular police and civilian registry. in this system, Hezbollah, not the police, apply and enforce religious rules. And as confirmed by Qutaiba, the emir of the police could not issue decisions on ta'zir. Given that Ansar ad-Din was following a standard and widely accepted system of Islamic governance, Mr. al-Hassan could not have possibly known that his participation would, in and of itself, be contrary to international law. In the prosecution closing arguments, we were shown a video where Mr. al-Hassan is portrayed to have said he should defend Islamic law until he dies. This is not an extremist pact or a hostile statement. This is an expression of belief, a belief that made it impossible for Mr. al-Hassan to disobey religious orders or take the risk of departing from his faith. We have, for example, heard witness D272 testify that while he might not be personally in favor of applying some of the Sharia rules, he was simply incapable of contradicting them. Witness D213 also said that as a Muslim, he could not be opposed to Sharia. D240 said that Sharia was recognized in Timbuktu and by the majority of Muslims. Prosecution witness P654 explained how, before 2012, each community in Timbuktu had a Qadi, referred matters to customary chiefs, local imams, and Timbuktu, and I quote, Timbuktu has always functioned like this. Imam Dawood, a local notable who was also a member of the Islamic Tribunal at the time, said, and the quote is in French,
No justice is better than divine justice.
This position does not turn these individuals into extremists. This is a belief shared by many other individuals from the Muslim faith, including Mr. al-Hassan. This is the belief and obligation that Mr. al-Hassan complied with, and that should not be punished with an extremist label. I now moved on to part 4 of this section, Your Honors, and it concerns the Islamic Tribunal's methodology. A prosecution witness testified that the Islamic Tribunal had to leave no stone unturned to ascertain the truth. He and other witnesses said that the Islamic Tribunal conducted its own investigations from scratch. We have examples of the Islamic Tribunal's hearings. The tribunal notes thoroughly demonstrate how the judges heard the witnesses and took note of their accounts. And again, their notes contain no indication of a role played by the police in the investigations whatsoever. This is item 124 on the defense list. The prosecution's claim that the tribunal judgment was based on the police reports is baseless. Besides matching names and dates, no progress in this trial was made to provide the necessary link between the alleged reports and the Islamic Tribunal findings. And today we are right where we started, with no proof of the prosecution allegations at all. So we are left with what we see. And what we see at most is that none of the Islamic Tribunal judgments even mention the existence of the Islamic police reports. None of the Islamic Tribunal judgments acknowledge any role played by the police in the findings issued by the tribunal. We have also heard before this chamber a prosecution witness who testified that Mr. al-Hassan did not have any influence over the court and did not contribute in any way to the decisions reached by the court. He also testified that Mr. al-Hassan did not take part in any court duties. Incidents must therefore be assessed on a case-by-case basis, and no assumptions should be made on the role, if any, of Mr. al-Hassan or the police in the proceedings before the Islamic Tribunal. Now I move to the last part of our submissions in this section concerning the voluntary aspect of approaching the police. The prosecution has called evidence of many cases of individuals who were seeking protection from thieves and bandits women who were ill-treated by their husbands, people who were claiming debts, people who wanted to protect their commerce or land, others who wanted to retrieve property stolen by looters, and others who simply wanted to honor contractual obligations. D240 affirmed that no pressure or influence was applied when he appeared as a witness before the Islamic Tribunal. The population continued to approach the police voluntarily and lodged complaints all throughout 2012, simply because it was useful to them and because their rights were preserved. And this is what Mr. Al-Hassan would have seen. This is what Mr. Al-Hassan would have understood. And not only did the population continue to approach the police with their concerns, but they were also supportive of the role it played in deterring theft. They continued to file complaints of theft after the amputation, until as late as September 2012 to early December 2012. And here I refer to incidents 24, 27, and 35. These were incidents filed by members of the Arab community against members of the Arab community, and we have heard evidence that the Arab community applied Sharia before 2012. Notables deplored theft in the greatest terms. Prosecution witness P4, speaking about a theft case of fuel used by the population, said, and I quote,
"We are ashamed of all these practices of the Timbuktu people, we who are proud of our values, who are so honourable, so proud. What a baseness, what a crime of theft, what dishonour."
Fin de citation.
End of quote.
We have heard evidence about the locals calling the green number provided by the groups in the middle of the night asking for help, and they were provided with immediate assistance, as confirmed by witness D554. The Islamic police performed its tasks without discrimination based on ethnicity or tribe or social status, as confirmed by prosecution witnesses P65, P150, and defense witnesses D93, D315, D551, and D553. Your Honours, insofar as this evidence negates knowledge or assists on the affirmative defences, and this will be addressed shortly by Dr. Gary, but at this stage, we submit that the evidence is such that the prosecution simply cannot prove there were criminal acts nor a common purpose arising from the police reports. And it follows that there is no evidence, Your Honours, Mr. Al-Hassan was anything more than a low-level clerk, acting on orders in accordance with decisions made with basic judicial guarantees and in accordance with public acceptance and understanding. Thank you. With your leave, Your Honour, I will pass the microphone to Dr. Gary.
Just pass me the lectern.
Merci beaucoup.
Thank you very much, Maître Youssef, for your brilliant and eloquent presentation. I now give the floor to Ms. Gary. Dr. Gary, you have the floor.
Mr. President, Your Honours, I will speak very, very briefly on the important context of Islamic law and the affirmative defences, and close on behalf of the defence for Mr. Al-Hassan. I start with a summary of the situation and context in 2012. The great power of this International Criminal Court is its ability to make simultaneous inquiry into a situation and the potential criminal liability of an accused person within that situation. It is a power that is intended to have universal reach, with a vision of international law that includes the Muslim world. It is a power that must be exercised in context and with great responsibility. When this chamber sits down to make findings on the situation in Mali in 2012, we submit it must be recalled that Timbuktu is and always was traditionally, culturally, a major hub of Islamic civilization. For centuries, Timbuktu has thrived as a centre of Islamic culture and learning. It is appropriate, we submit, to conclude on the evidence, in this case, that Islam is indeed the soul of Mali. In 2012, Mali was also a post-colonial society, and as Ms. Pradhan has explained before me, it is commonly understood that post-colonial or neo-colonial instability is not the same as an armed conflict. Instability is a feature of history. It is a feature of Mali history. It is our submission that central to this case is the need to understand Mali and to understand Islam and the Muslim society in Mali, which 90% of the population adhere to. The evidence explains that the term Islamic law covers the entire system of law and jurisprudence associated with the religion of Islam. In many ways, like any jurisprudence, it can be divided into two parts, namely the primary sources of law, Sharia, and the secondary sources of law with the methodology used to deduce and apply the law, Islamic jurisprudence or fiqh. These are considered by Muslims to be of divine revelation and thus create the immutable part of Islamic law. You can conclude on the evidence that in Mali, Islamic or Sharia law is and always has been the heart of the population's cultural, legal and political society. You have heard evidence that there are various schools of thought. The evidence is such that you may infer a lack of consensus as between schools. The prosecution did not call independent expert evidence, but you have clear evidence that there are differences in interpretation of the Quran by scholars and judges. However, that does not make the work of Ansar Deen nor the Islamic Tribunal extreme. Interpretation is fundamental in law and is fundamental in Islamic law. It is the element that separates the madhahib, the ways to act, from one another. It is the way. While there is no question that the Quran is the first source of Sharia, there is no evidence to enable you to choose differences among the schools, nor to rank other sources of Islamic law, nor should you do so. The sole evidence is that the Maliki school of thought may have been followed. At best, this is evidence of an attempt at stability and legal certainty. It is not evidence of an extreme ideology. This is not a case where mock trials of the population were held. It is a case where governance and law was legitimate. It is not for this chamber to impose a selective approach to Islam on Mali in 2012. Ansar Deen was not bringing new rules, as alleged or at all, but protecting the traditions, population and heritage of the city and the region, and, for example, appointing scholars and having structures which ensured that the decisions made were valid in Islamic law and would be accepted as valid by the population. The libraries still stand and the manuscripts are safe. Whilst crisis in name, any crisis in fact was averted through peaceful consultation with local dignitaries, an Islamic tradition reflecting the usual Islamic nature of Ansar Deen. The evidence is that Ansar Deen governed according to customary Islamic law and established practice, and the police were subordinate, not part of any governance structure or policy making. We know this from the evidence of Abu Zaid's instructions that policy and procedures were decided by the emir, and from the evidence of Qutaiba's interview, which clearly restricted the powers of the police to a secondary organ. Timbuktu has never been a Western cosmopolitan city. It was socially conservative and controlled by religious notables where traditional values were preferred. Before, during and after 2012, Qadis and sheikhs applied Sharia to resolve disputes in matters ranging from marriages, divorce, adultery, theft and murder with valid interpretation. No expert has suggested otherwise. The Malian authorities were aware these judges exercised this role, and Zardine continued this tradition, and those employed, like young Mr. Al-Hassan, worked in a customary Islamic situation and context. It therefore cannot be inferred from the Islamic processes and decisions made that any international crime would occur in the ordinary course of events, nor that any crime was virtually certain. To suggest there were no basic guarantees is tantamount to suggesting that Mali is to be held to a higher standard than most state parties in a transitional situation, particularly when people in an Islamic country needed the basic Islamic structures that they were afforded. As Ms. Taylor has explained, Ansardine can and should be characterised as at most a national group. It did not amalgamate with AQIM. Ansardine restored services, brought security and access to justice according to customary Islamic law. Its member Hooker has since been commended and not prosecuted. This is good evidence that Mr. Al-Hassan was never party to an unlawful conflict because there was no armed conflict. There was an attempt at stability and nothing more. A proper analysis month by month of the situation in Mali in 2012, as presented by Ms. Taylor, is that there was no criminal purpose or policy. Turning to the accused person, the evidence shows that Mr. Al-Hassan is and was a respectable member of the ancient Tuareg tribe. Mr. Al-Hassan stayed in Timbuktu out of necessity. He was not zealous, but a Muslim doing his job properly. As Mr. Youssef has explained, in 2012, Mr. Al-Hassan served his fellow people as a low-level subordinate to whom the governance of Timbuktu, through customary Islamic law and principles, was lawful, including the punishments according to Sharia. His were honest and genuine and reasonable beliefs. On Tuesday, the apparent zenith of the prosecution case this week was a video at their item 103 in which Mr. Al-Hassan says that he believed Islam was being followed. No caliphate, nothing extreme, no AQIM propaganda, just Islam. Allegedly having keys to handcuffs, a walkie-talkie or a phone, as suggested by the prosecution on Tuesday this week, does not make a leader. Even the prosecution outline on Tuesday itself showed that Mr. Al-Hassan's role was of an ordinary police officer. As Madame Beaulieu-Lucier has explained, marital relationships were without Mr. Al-Hassan's knowledge or were consensual or appeared so, even if this chamber concludes that created a mistake. He did not commit rape, nor was he complicit in any sexual offence or persecution. On punishments, for example, the prosecution played a video of Mr. Al-Hassan accompanying Musa to fulfil his sentence. It must be remembered that this sentence of Musa was for murder, where the accused man had shot a farmer, where Musa's defence of self-defence was rejected in properly held proceedings demonstrating basic trial rights were indeed afforded. It misleads this chamber to suggest that Mr. Al-Hassan was anything other than being supportive. The actual evidence was that he talked to the family about Dia, but they asked for Kisas. So at most, Musa had Mr. Al-Hassan's company as the sentence proceeded. This chamber can properly conclude that Mr. Al-Hassan's role was one of service, not of criminal conduct or purpose, and not of persecution. He plainly had no purpose to subjugate or denigrate anyone. He worked as an ordinary police officer, a civil functionary doing his best for his family and the population according to ordinary Islamic structures. All of this is clear from the evidence. Superficially, the core issue is simple. Criminal liability only flows where a person is aware that a circumstance exists or a consequence will occur in the ordinary course of events. In this case, knowledge is more complex because of the way that the prosecution put their case. They must prove knowledge of the situation as they suggest it was, knowledge of the alleged purpose, if such a purpose can be proved at all, as well as knowledge of the alleged individual crimes within Mali. This inevitably contains some objective factors, as the Chamber must make findings on the ordinary course of events in Mali, where Islamic law was customary and governance and judgments in 2012 were through Islamic law. It is our submission, taking this approach, there is no safe foundation to convict Mr. Al-Hassan. It is also not a mere knowledge test. That would remove the operation of intention. We say the proper approach can be expressed as follows. He did not know the essential facts about the alleged crimes or the alleged purpose, and his liability is excused because he was, or may have been, which allows for reasonable doubt, operating under a mistake in circumstances of necessity and bound to follow superior orders. It is in this way that the defences of mistake of fact or law, superior orders and duress are applicable to all the confirmed charges, because they are all relevant to his alleged knowledge, intention and conduct. For example, not only did he not participate in the subjugation of women, he did not know the use of Islamic law was unlawful, because in Mali in 2012, it wasn't. The prosecution conceded in their closing address on Tuesday that the religion was Islam, and the request by Ayad Ag Ghali was simply to abide by the Quran. We submit that it is impossible for this court to infer, for example, that regulating smoking and drinking, theft or clothing, as set out in the Quran, would mean that Mr. Al-Hassan knew international crimes were being or would be committed. Mr. Al-Hassan, a family man and police officer, was tasked with following Islamic governance and law and obliged to do so. It was lawful and he believed it was lawful, even if this chamber concludes he was mistaken. The suggestion in paragraph 574 of the prosecution final brief that the defence has responsibility to substantiate its claims that affirmative defences apply is misconceived. As set out in detail in our final brief and response, substantiation suggests a legal burden on the accused, whereas it is an evidential burden. Assuming what the prosecution meant was that there must be evidence of substance for the chamber to consider on the affirmative defences, we submit this has been achieved. On mistake, the fact that there were meetings with local dignitaries, that issues were listened to and adaptations were made was not meaningfully challenged. There was evidence that Ansardine restored services and gave free health care, which allows for an inference of what Mr. Al-Hassan saw in terms of legitimacy. Society was visibly Islamic. On duress, discrimination of the Tuareg was rife. This chamber must reject the legal representative of victims' submissions that being a Tuareg is equated with criminality. On superior orders, bearing in mind that this is both a defence and the context for any mistake, there is evidence that the supreme authority was held by the Islamic Tribunal and the absolute prerogative was Adam's, then Khaled's and Abu Dar's. The evidence demonstrates that Timbuktu is and was Islamic and Mr. Al-Hassan functioned within Islamic law and governance. Returning to the prosecution video at their item 103, we can see and hear Mr. Al-Hassan's honest and genuine and reasonable belief that Islamic law was being applied. Nothing extreme, nothing foreign. He literally says Islam. The logical conclusion is that there was no extreme vision, and if there was any mistake, it was honest and reasonable, and any conduct was unavoidable. Put another way, there is ample evidence that a reasonable person in Mr. Al-Hassan's position would believe that people were governed and judged according to Islamic law, even if using an interpretation, and that Islamic punishments were carried out following a proper order. Accordingly, even if this chamber thinks that Mr. Al-Hassan was operating under a mistake of fact or law, he is excused. The fact that the public engaged extensively in that system suggests this was a belief held by many, making it reasonable for Mr. Al-Hassan to believe as he did. P150, a witness, said that Sharia was to be followed. On this alone, Mr. Al-Hassan can reasonably claim he acted lawfully. Intention cannot be inferred from circumstances of legitimacy, mistake, or necessity. He also played no role in the decision to apply Sharia or subsequent decisions concerning how it should be interpreted and applied. Ansardine's work was directed towards ensuring protection, harmony and positive outcomes for the local population as a whole, which, to Mr. Al-Hassan, was a lawful result. Notably, local imams also counselled the local population to obey and cooperate with the groups. Given this backdrop, it was not unreasonable for Mr. Al-Hassan to act as he did with a positive impact for the local population. Refusal would have placed Mr. Al-Hassan and his family in grave danger. His alleged presence at punishments was mandated. He was never empowered with the responsibility or power to decide punishments. The sole area of discretion afforded to him was mediation and reconciliation, which he did. As I have said, it is too great a stretch to decide that international crimes can be constructed from interpretive Islamic law and governance, and reasonable doubt as to knowledge is sufficient to acquit. There is sufficient evidence for this chamber to conclude that governance and judicial decision-making were lawful and therefore lawful to Mr. Al-Hassan, particularly as a Muslim Tuareg, subject to orders, even if this chamber concludes he was mistaken. The suggestion that Mr. Al-Hassan could have fled is fanciful. The prosecution simply cannot rebut the reality in that context. Mr. Al-Hassan's actions were a reasonable and necessary response, allowing him to protect himself, the local population and his family. So, in conclusion, on behalf of the defence, in a criminal trial, we submit that however confronting some evidence may be, the consequences cannot be laid at the door of Mr. Al-Hassan. This chamber must maintain standards of both law and evidential process and develop the law on knowledge and affirmative defences to function safely on the factors we have identified. The prosecution written and oral submissions were strikingly absent of law, leaving you to grapple with the legal principles we have outlined. The evidence we have of Mr. Al-Hassan's knowledge is that he was working where Sharia was applied. He believed this would bring justice for the community, and he worked for the community. The prosecution case, and I have about 12 words left, if I may, the prosecution case suffers from...
Yes, please, you may.
The prosecution case suffers from misreporting, flawed evidence gathering, reliance on torture-tainted interrogations, and myopia on Islamic law, such that there is reasonable doubt on every charge when Mali is properly understood and the international criminal law in the Rome Statute is properly applied. The correct outcome for Mr. Al-Hassan is to conclude his conduct was not unlawful nor intended to be, and to acquit of all charges. The two words you must find are not guilty. Thank you.
Presiding Judge, thank you very much, Dr. Guéry, for your very clear and eloquent presentation. Ms. Taylor, what is the situation? Is this the end of your closing arguments?
Thank you very much. That concludes our presentations.
Merci beaucoup, Maître Taylor.
Presiding Judge, thank you very much, Ms. Taylor. Thank you for your last submissions, your very high-quality submissions. presented by yourself and your colleagues. We shall now move to the questions which the Chamber wishes to put. Judge Akane will put the first question, and we shall now listen to that.
Thank you, Presiding Judge. The prosecution described P0580's daughter in paragraph 261, 264, and 318 of its final brief. The defense described P0580's daughter and made references to a name that was previously communicated to the parties by email in paragraphs 333, 460, 464, and 467 of its final brief. My first question is, do all these descriptions of P0580's daughter or to the name previously communicated to the parties by email refer to the same person as P0580's 7-year-old daughter, reference to paragraph 287 of the confirmation decision? This is the first question. And secondly, the prosecution refers to P0580's eldest daughter in its trial brief at paragraph 142. The prosecution makes no mention of this eldest daughter of its, in its closing brief, but rather refers only to P0580's 7-year-old daughter. Does this mean that the relevant parts of the confirmation decision that have been communicated to the parties by email refer to P0580's 7-year-old daughter? I'd like to give the floor to the prosecution first. If you need to go into private session, please do so with the presiding judge's leave.
Monsieur le procureur, vous avez la parole.
Presiding Judge. Prosecutor, the floor is yours. If you feel that we need to move into private session, you should let me know. Mr. Duterte. First of all, Your Honour, thank you for that question, because that will allow me to clarify something which it seems was not clear in our submissions. So thank you for this opportunity. I think that part of my answer can be given in open court and part in a closed session. That would allow us to remain in open court for as long as possible, although, of course, the court officer will have to do some extra work. So I shall start in open session, and then we can move into closed session, and then perhaps return to public session if the Chamber agrees. Presiding Judge. Yes, absolutely. Please proceed, Mr. Duterte. Indeed, Your Honours. As regards the first part of the question, the daughter of P0580, who is mentioned in the prosecutor's final brief, is the same as the daughter of P580, who is referred to in the preliminary decision of Chamber 1. Or rather, in the decision of pretrial Chamber 1, I refer there to the decision confirming the charges. And there I would refer to the specific charges 1, 2, 3, 4, 5, and 6. So if I could now ask for us to move into closed session, please, Your Honour. Presiding Judge, certainly. Court Officer, could you take us into private session, please?
We're back in open session, Mr. President.
Merci beaucoup.
Presiding Judge, thank you. Prosecutor, you have the floor. Mr. Dutertre. Thank you, Your Honour. Now, as regards the second part of your question, the position of the Office of the Prosecutor is that the daughter of P0580, who is referred to in the decision confirming the charges, is the 7-year-old daughter and not the eldest daughter. It's true that the prosecution does refer to the eldest daughter of P0580 in its trial brief. That is because in an interview with the prosecution, witness P0642 had recounted how their eldest daughter had been detained and whipped. However, the violence which was suffered by the eldest daughter is not included in the charges, and the reference to the eldest daughter, therefore, Your Honours, was meant simply to demonstrate the scale of the violence and the type of harassment that was suffered by the family of P0580 and P0642. So this completes my answer to your first question, the two parts of that first question. I hope that I have provided sufficient clarification.
Thank you, Mr. Prosecutor. I will now turn to the legal representative of the victims. Would you like to make some observations in relation to this question, if any? Mr. Sita?
Merci, Madame.
Mr. Sita. Thank you, Your Honour, for offering us the floor. However, the legal representatives for victims do not have any specific comments to make on this point. Thank you.
Thank you very much. Now, I'd like to give the floor to the defense. Mr. Taylor?
If I may just set myself up a little bit. It's quite a lot of bias. Thank you very much, Mr. President, Your Honours. I believe I can answer in open session if I refer to the youngest daughter as the first daughter and the eldest daughter as the second daughter, if that would be convenient for the chamber. And I won't refer to the specific age, but I will refer to the young age of the first daughter on the understanding that the chamber is aware of that age.
That's fine.
Mr. President, Your Honours, it is a submission of the defence that the name of the first daughter, as mentioned in our closing brief, is the same and is in fact the first daughter, the youngest. But it is also our position that the facts are fundamentally different, such that the incidents addressed in our brief and in the evidence do not correspond to the facts confirmed by the chamber concerning the youngest daughter. I will first go through the facts as confirmed by the chamber and then the developments afterwards. And as the prosecutor has addressed you today, at the time of the confirmation decision, the pretrial chamber only had the statement of 580. And the chamber's decision was framed on the basis of his evidence. And in that decision, at paragraph 301, they made the following findings concerning that daughter. First, that she was very young. Second, that she visited P580 when he was detained by Hamid Musa, and then locked up the place where women were detained. And it was after she was taken to the police and thrown into the prison for women that she was assaulted twice. She was then taken to a hospital and whipped 20 times. So they're the confirmed facts concerning this youngest daughter. And when the chamber confirmed these incidents, they placed particular emphasis on her young age and the fact that the physical violence had taken place while she was detained. So that was a key component of the confirmed incident concerning her. And when this trial chamber issued the self-contained set of charges, they described the incidents as follows: acts of violence and other forms of ill treatment committed against P580's daughter, who was arrested in Timbuktu, detained and sentenced by the Hezbollah to whipping, which sentence was carried out in certain time periods. So again, this indicates that the gravamen of the incident pertained to her detention and sentencing by Hezbollah. It's our position that the chamber can't replace the names of the two daughters, but they also can't use the new facts for the youngest daughter. And first, that's because there's been no notice of such a fundamental change in the charges, and it would exceed the chamber's competence to mould the charge facts to fit the evidence. And second, P642's testimony doesn't prove the confirmed charges, irrespective of whether you base it on the youngest or the eldest daughter. Now, in terms of the issue of notice, Article 74 prescribes that the chamber can only be based on facts and circumstances confirmed by the pretrial chamber. And the appeals chamber judgment issued on 1st of July 2021 in this case, and that's the filing 1562, paragraph 1, confirmed that Article 74.2 binds the trial chamber to the facts and circumstances described in the charge. And they use that word binds deliberately. And we have a host of case law from the appeals chamber confirming that there's a fundamental distinction between changing the legal characterization of the facts and circumstances of the charges and confirming or changing the facts themselves. And for the latter, resort has to be had to Article 61.9. And I refer to the appeals chamber's judgment in Labunga 2205, that's the number, paragraph 94. In that same judgment, the appeals chamber cautioned in particular that to give the trial chamber the power to introduce new facts would usurp the power of the prosecutor and would violate the proper distribution of powers within the statute. Effectively, the chamber would become a prosecutor, and that was at paragraph 94. Now, I am aware that in the judgment issued in this case, the 1st of July judgment, the appeals chamber did say in case of ambiguity, the chamber could look at the DCC, that is the document containing the charges, to see if there's an ambiguity. But here there was no ambiguity in the decision confirming the charges, and these additional new facts concerning the first order were never in the prosecution's own charges. So you can't extrapolate from the charges because these new facts simply weren't there. Similarly, the fact that the new facts are similar to other facts or that they fall within the charged time period or location is neither relevant nor sufficient. As stated by the appeals chamber in Labunga, the fact that new facts have come to light during the trial and build a unity from the procedural point of view with the course of events described in the charges does not cure a breach of Article 74, subsection 2 of the statute. And that's paragraph 92 of the judgment with the number of 2205. Now, these principles have to be interpreted in a way that's consistent with our right to timely notice. The prosecution could have amended the charges after they interviewed P642, after they received slightly different facts concerning her, but they chose not to do so. They wanted to have their cake and eat it too. They wanted to rely on the more serious allegations from P580, but at the end, they dropped P580 with no notice to the defence and no ability for us to recalibrate our investigation or case. Even then, they made no application or no notice that they were going to rely on new facts rather than the confirmed incidents. Now, in terms of my second aspect, that P642's evidence doesn't relate to the confirmed charges, this applies irrespective of whether you assume it's the first order or the second daughter. If we assume it's the youngest daughter, the charges were predicated on the fact that she was punished for not wearing a veil. and that she suffered the mistreatment at the BMS itself and was flogged. But P642's evidence does not confirm or relate to any of those charged incidents. At transcript 156, page 14, line 1, when asked what happened to her daughter, she said, "I couldn't tell you." So we have none of those confirmed details that were fundamental components of the charged incidents. She also provided absolutely no evidence concerning the eldest daughter. None. The prosecutor didn't even pose a single question to her on that point. There's therefore absolutely no basis for this chamber to issue findings on either the first daughter, given that the evidence does not correspond to the confirmed charges and constitutes entirely new incidents which were never confirmed, nor is there any basis for the chamber to enter a conviction in relation to the second daughter, given that we had no evidence come out at trial, and the prosecution itself today has confirmed that they're not bringing charges in relation to the eldest daughter. Thank you very much.
Thank you very much. I'll back to President. Thank you.
Je remercie Madame la
Presiding Judge, thank you very much, Judge, again for your question. I would also thank the parties and participants for their contributions. I will now turn to Judge Prost, who has a second question to put. Judge Prost.
Thank you, President. I have a similar question for clarification, and it has been framed in a way that it can be presented in public session, but should either any of the party participants need to go to private session for a response, please seek leave from the presiding judge. The confirmation decision in paragraphs 610 and 611 referred to the place where P538 was detained on several occasions. The chamber also notes that in paragraph 261 of the prosecution trial brief, the prosecution placed the location of P538's alleged rape by multiple men at this same place. In its final brief, the prosecution stated that P538 was temporarily detained in a place, and that's in quotations, which the witness described and called by a particular name, and raped by multiple different men. I'd just like to clarify what the prosecution's position is as to the place where P538 was detained during her alleged final detention. And if you can please specify the evidence supporting that position. Thank you.
Monsieur le procureur, vous avez la...
Prosecutor, you have the floor.
Je vous remercie, Madame la Juge.
Thank you, Your Honour. I'm going to answer in public without going into private session, mentioning the place that the judge took the precaution not to mention it, but I would believe we can do so subject to the control of the chamber.
Alors, en ce qui concerne...
Now, where it concerns the second question, Your Honours, concerning P538, the position of the prosecution is that the last location where P538 was detained corresponds to Hotel La Maison, which served as the headquarters for the Islamic Tribunal, which applied rules and sanctions which did not exist in a secular state, and where only criminal law applied from the Malian state applied. During the testimony, P538 testified that she was informed of Cha-Cha-Cha, that she was locked up in Chichester, and that's where they rendered justice. And she also clarified that Cha-Cha-Cha was a neighbourhood which was next to the Baraju neighbourhood. Now, a first point is that it's not just P538 who spoke about the Cha-Cha-Cha location. Two witnesses, P557 and 520, also referred to a neighborhood Cha-Cha-Cha or Chi-Chi-Cha. First of all, P557 testified that he was taken to a hotel in a neighborhood called Cha-Cha-Cha. And he explained that that's where people were tried. So, in terms of the location, that corroborates what P538 said, who said that she was locked up at Cha-Cha-Cha, and that it was there where they rendered justice. So, in terms of the location, it's compatible. Now, P520 also mentioned a neighborhood called Cha-Cha-Cha, which was situated around the Yobutao market. And P520 added, Baraju and Cha-Cha-Cha is the same thing. You have it in the transcript, 149, lines 20 to page 36, line 9. So transcript 149, page 36, lines 20 to page 37, line 9. I have the other references for P557, but I didn't want to interrupt the answer for too long. And so, if we put in parallel P520 and P538, according to which Cha-Cha-Cha was a neighborhood which was next to a Baraju neighborhood, that is also compatible. And I would state that Hotel La Maison is well situated in the Baraju neighborhood, and you have the maps in annex to the brief, which make it possible to locate them. To put it in other terms, what P538, 520 and 557 say with regards to Cha-Cha-Cha is the location and the location of the tribunal, Hotel La Maison, are coherent. They are also in accordance with the reality in the field. As I said, there are the maps, but also you can see it in the reports of the two experts, P55 and P57. And OTP 0060 1920, page 1932. I come to a second point, and that's the description of the building in Cha-Cha-Cha as made by P538 is corroborated by the evidence. P538 testified that there were several rooms in the Cha-Cha-Cha building and indicated that the room in which that person was detained was on the ground floor. And she said that it was on the floor in which the judgments were made. And as detailed in the report of experts 55 and 57, there was indeed several rooms on the bottom floor of Hotel La Maison. There were photographs, there were drawings, maps, and several witnesses, including P626 and 202 and P50 indeed mentioned that the tribunal was on the higher floor. And you will see it in videos as well as the interactive media intended into evidence. Now, at this stage, I should say that the defence contests the account of P538 concerning the last detention in referring to the testimony of D202, according to which nobody remained in the building of the tribunal overnight. But D202 admits himself that he never spent the night there. So he's not able to know what happened in that place during the night when he wasn't there. In total, the evidence in the case file indicates that the Cha-Cha-Cha building described by P538 during her testimony does correspond with Hotel La Maison. Now, certainly in the trial brief, the prosecution refers to the written statement of 538, and that's the available evidence. At the present stage, the prosecution is of course referring to the statement under oath given in the courtroom before your chamber. And I have to stress that the evidence does not demonstrate any bad faith on the part of P538. Her testimony with regards to location of the last place of detention and it corroborates with the evidence. And the testimony concerning the forced marriage as well, with a member of Ansar Dine and Akim, is coherent with and is corroborated with documentary evidence. And I didn't mention it because we could go into something that is identifying. But it's in the case file of evidence and our written brief, final brief. And the defence had the opportunity to cross-examine P538 on all the points that were of relevance to them. By way of conclusion, the Chamber will assess in all sovereignty the testimony of this victim, taking, of course, into account the fact that this is a person who is illiterate and for whom VWS recommended at the time special measures to be put into place for the testimony, including the use of short questions and simple questions and language that was easy to understand. I would like to thank you, Your Honours, Your Honour.
Thank you very much, Mr. Duterte. I turn to the legal representatives of victims to see if there's any comment that you wish to make on this particular question.
Je vous remercie.
I would like to thank you, Your Honour. The legal representatives for this second question do not have any particular observations to make. Thank you.
Thank you very much. I turn then to the defence. Ms. Taylor, you have the la parole.
Thank you very much, Mr. President, Your Honours. Your Honours, it's our submission that there are two possible judicial responses to this issue, and I'll go through each of them in turn. The first, it's clear that P538's testimony deviated in a material manner from the confirmed facts and circumstances. And we can see that the location of a detention is a material fact if you look at the charges. In particular, the prosecution pleaded in their document containing the charges expressly that she was imprisoned at the Gouvernorat, and that was paragraph 802 of the document of the charges. Then, at paragraph 813, they argued that the pretrial chamber had to put specific emphasis on the fact that she was detained at the Gouvernorat in order to find that her husband was in fact a member of Ansar Dine and not a member of the MNLA as stated in her statement. So it's clear that the location of her detention, as pleaded by the prosecutor, was a fundamental aspect of the confirmed charges. This change, this deviation in this material fact, was never notified to the defence timelessly through an amendment nor through disclosure. It only came out in her testimony. Even today, the prosecutor has confirmed that in their trial brief, they continued to state that she was detained at the Gouvernorat. And I've gone through the preparation log, which was the only information that we had, and even in the preparation log, when she reviewed her statements, she did not change the location of her detention. We can, however, see at page 20 that she was shown the video MLI OTP 00180249, which is a video of the Hotel Maison. So she saw all the rooms, she saw all the locations in this video during the preparation session, and it's there that she says, oh, this building is a cher. Even then, she doesn't say she's detained there. So this is something that we first heard, this new material fact, was on the stand. And we submit, Your Honours, that this mutation, this evolution in her testimony must also be construed in light of other changes and inconsistencies in her account. I draw your attention to the changes in the name of her husband, the changes in the association of the group to which he belonged. And I would also like to underscore that this was a witness whose name was not disclosed to the defence prior to the trial. It was a late disclosure witness. And as we've set out in our brief, as a result of that, we were unable to cross-examine P150 and P626 on this aspect. And that shows why this aspect, the location, is a crucial aspect for her account, because there were witnesses who could clearly controvert it. And without this material aspect, we were deprived of the ability from doing so. And even today, they've referred to D202, testifying that he left each night, but he also testified at transcript 204, page 29, lines 18 to 24, when people leave the courthouse, I would personally lock the courthouse and take away the keys with me. Now, when she testified, P538 said that she was there for more than one night. She never said she was taken in or out. So it's clearly implausible that she's not there during the day and suddenly comes in just after everyone leaves each and every night. That's a clearly implausible account, and in any case, it's an account we should have had when other witnesses who could have talked about it were on the stand. So for these reasons, not only do we have no timely notice, we also have clear, concrete prejudice. And these two factors mean that you can't rely on this for your judgment. My second point is that given that she said on the stand, under oath, that she was testified at the Sha and that it was the justice, that means that you can't now refer on her statement. You can't go beyond her sworn evidence and assume or infer that she actually meant somewhere else. And that's because the statute and rules are quite clear as to when the chamber can have recourse to a written account. And this isn't one of them. Her statement's not in evidence under Rule 68, and even today the prosecutor is averring that it's not the Gouvernorat. So we submit that there's no basis or foundation for the chamber in its judgment to conclude that it could be the Gouvernorat, given her sworn evidence. So on the basis of these two factors, first, the material mutation in her evidence for which we received no timely notice, coupled with the clear prejudice given our inability to investigate or cross-examine witnesses who could have clearly controverted her account, and two, the absence of any timely or confirmed facts concerning that correlate to her sworn testimony, there's no basis to convict in relation to her detention. Thank you very much.
Thank you very much, Ms. Taylor. Presiding Judge.
Je remercie Madame la juge.
I would like to thank Judge Prosh for her question, and of course I thank the parties and participants for their interventions. As such, we are coming to the end of the presentations of the oral submissions, the final submissions of the parties and participants. I see that there are no more requests for the floor. And before adjourning, I would like once again to thank the parties and the participants for their spirit of cooperation and for the good understanding between us that has reigned throughout this trial. The Chamber can only thank you for that. In accordance with Rule 142 of the Rules of Procedure and Evidence, the Chamber will withdraw in order to deliberate in private. The parties and participants and the public will be informed at the appropriate time of the date when the judgment will be rendered. Before concluding our session, as usual, I would like to thank the parties and participants, the interpreters and the court reporters, our public in the gallery, our public from afar, and, of course, our security officers. I wish everyone a very good day. We are going to adjourn. Court is adjourned.
We will